I will take you through my slide little later. First, I will try to give a load on claim. Just a moment. I will share the screen. Then I can. Okay, my screen is visible. Can you see my screen? Any of the participants?
Yes, sir. It's this.
Yes, sir.
Yeah, now we are going to discuss on the claims. I think most of you must be practicing as insolvency professional and must be as a liquidator or IRP or RP. So before moving on to this claim, so I thought I thought I can make it as a more deliberative session than kind of a unilateral thing where I alone discuss without knowing whether the points is reaching you or not. So now, just I want to understand from you, any one of the participants who were handling or would have dealt with the claim. The claim what we are going to discuss, is it the same under the Insolvency Bankruptcy Code and Companies Act? For both the purpose, is it the same or those are completely different? Let's try to understand this first, then we'll move on. Whether the claim, the legal connotation of claim changes for Insolvency Code comparing to other law, particularly a Companies Act. Is there any difference or both are only same? Any points? Any points from participants?
The claim is different. The claim is always different. In the CARP, it is different.
Yeah.
It is in the claim of liquidator, it is different.
Yeah, I see. You are. I think you are trying to address in terms of giving, filing a claim, submitting a claim. I'm asking in the legal sense whether the claim what we understand, what we could understand, for other purposes are same when it compared to when we come to the provisions of Insolvency Code, or is it different? That's what I'm trying to. Whether something concluded as a claim for the purpose of IBC can also be treated as a claim for any other purpose or under any other law.
Question is not clear, sir.
So I'm asking if a claim is accepted by the liquidator, right? Can that claim be a claim for the purpose of any other legislation for initiating any kind of suit or any filing any cases based on that the liquidator has accepted
Here, just a point of clarification is, in the case of a CIRP, the RP doesn't have the adjudicating power of accepting or rejecting the claim. In the case of a liquidator, he has the authority to reject or accept a claim. First point of consideration, which is there.
Yeah.
Second thing is, with regard to the claim status, it changes. For example, what is submitted in the CARP is not the same claim in the case of a liquidator.
Okay.
It has to be adjudicated, first of all. Second thing is, with regard to the documentation part of it, he has to be very clear. The documents have to be collated, corroborated, and confirmed that this is your claim.
Okay.
Whereas in the case of CIRP, it is only collation of claim. You are not adjudicating a claim.
Agreed.
It's only just collecting the document and confirming it And third thing is with regard to the verification of the books of accounts. In the case of CARP, the recent judgment has made it that if the claim is not received, you have to take that into consideration while you accept a claim. But in the case of a liquidator, the books of accounts are to be considered, but one thing is the claim has to be filed with regard to anybody for that matter.
Yeah. So I think recent orders, as you said, many orders have come, and whatever you deliberated now, I think all these orders have conveyed. Actually, though the code does not provide very clearly on these points, but orders keep coming and giving clarity case to case, and we are now obligated to follow.
Actually,
Now, yeah.
hello. And actually,
Yeah,
our
please.
fellow told that the claim is different from CIRP or liquidation. Claim is claim. Anybody who are filing that he has the kind of, he have to take money from the company. It is a claim. He is submitting or not. It is different thing. But the claim, the RP or IRP have the power. If it is a genuine claim, he can accept. He is not genuine, he is not will accept. If anybody is a party, is a problem, he go to a executing authority to challenge to the IRP,
Exactly.
RP or liquidator.
Oh, no, this is the point I wanted to ask you. See, that's why I put that question first, because we are going to discuss on claim, treatment of claim. So before getting into treatment, we need to understand what exactly the claim, because that if there is no clarity on the connotation claim, then difficult for us to appreciate how it should be verified, how it should be treated, all that. So my point was that only, we all we are insolvency professionals and we are into practice. So that's why I wanted to take your point before giving the question. I wanted to ask this only, that before, see, the moment the claim is adjudicated by liquidator, as one of our friends said, the RP has got power only to collect the claim, and the liquidator has got adjudicate. It is settled, and so there's a very good judgment of Supreme Court. It settled a law today that liquidator alone can adjudicate the claim. Now, I was putting this question to understand the claim in a wider perspective, that if once the claim is adjudicated by the liquidator under insolvency bankruptcy code, in case he is not able to get paid out of the realization in the liquidation asset, asset liquidated, or whatever the process of followed by the liquidator after selling the assets, he is not able to settle the claim. My point why I was asking this particular word, claim. Of course, we are going to deal with the terminology called claim only for the purpose of insolvency bankruptcy code, no doubt. But I wanted to understand a wider perspective so that we can try to see that more points we are bringing on table. So the claim, once the liquidator accepts or adjudicate, and he is not in a position to pay because there is no realization as that he could make the payment in the liquidation process under IBC. My point I was putting across, that whether this claim can be taken as a legal claim for any other purpose outside insolvency bankruptcy code. That's a question. It's a very general question, I know, but I wanted to understand what is the legal wider perspective of the claim, the word called claim.
Once the liquidation process starts under CIRP, I don't think that any person has the right to claim elsewhere once it is settled over here, whether it is settled or not.
So it survive and die in the process itself.
Yes.
Take it that way. Can we take it that way?
Yes, sir.
Yes. So that's
Yeah,
only.
sir, are you talking about the set off or counter claim like that?
No, it is basically a claim. Counter claim. The claim includes counter claim and much more. We can deliberate other aspects of the claim. But I am talking about the claim which is adjudicated by liquidator, which is not paid off in the liquidation process.
Now, nobody can claim further, before any other forum.
Okay, so that means it survives and die in the code itself, in the process,
Yes.
in the liquidation process under the code, INB code itself. Fine. So this only I wanted to, just to deliberate, because here, just a moment. So now, why I was this particular question, now I'll tell you. Now, if you see section 3 and class 3, 6 of IBC, claim is right to payment. In fact, the word right to payment comes both in class, subclass A and B also, both right to payment. So this only I wanted to know. I wanted your point that right to payment, that only decides what is claimed. So what is right to payment? Is it decided what is right to payment? Is it defined under IPC? What is right to payment? Whether the right to payment is defined under the code. What is right to payment? Because it goes on to say whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, unsecured. So it is very open. If there is a right to payment, then it's called a claim. It falls within the category of claim. Can you give your inputs on what is right to payments? What they are trying to mean by that, right?
It is not defined under the IBC.
Correct. What they mean by that?
The right to payment, that the entitlement of getting the payment from the CD, that due to service providing or due to supply of goods, due to any reason arising out of contract, arising out of any understanding.
Right. Now,
or by way of adjudicating authority also, by way of court order also, or arbitration award also.
no, it says the right to payment, whether or not such right is reduced to judgment, whether it is, see what they are making it, they are making it very open that the right need not to be decided by judgment, may or may not be decided by judgment, may or may not be a disputed or undisputed. So may or may not be. So this is what the whole drafting, the articulation has done to define the claim. So that means right to payment is sufficient.
Yes, it's a very wide scope.
Exactly. That only I wanted to. Then only when we deliberate other points, it is easy for you to appreciate why there so many orders are keep coming. That claim, of course, there are so many orders have come. There are orders come in, to workmen and employee, then the statutory authorities, financial creditors, and operation creditors. There are so many orders have come. Now, why these many orders are coming? Why? Because why it is not completely within course, the claim is not, it's why it is getting expanded day by day by orders, means orders of various courts. Because the claim is nothing but a right to payment. Okay. And second one, class B, if you see, it's a right to remedy for breach of contract. So, how it differs from class A, that I want to understand. So, right to payment itself, that somebody breaches some understanding, that how the situation A is not covered, so situation B arises in that. Can I say situation B is already covered in situation A? Do you agree? Do you agree this point? Or if you disagree, please share your thoughts on that.
Sir, right to claim is remedy for breach of contract, nothing to do with the right to payment. The right to remedy is for the breach of conditions as per the contract.
Okay.
Failure on the other party to comply with the terms. That's all.
We say this is a compensation. Can we
Yes,
say
sir.
45B as a compensation?
It is not a compensation, sir. We have to see the terms and conditions. What is covered in the contract?
So right
Then only we have to say there is a compensation or something else.
no, right to remedy for breach of contract. That means the covenant of the contract is breached. Therefore, the remedy has to be provided. So the
Compensation is entirely different from the.
I understand. That's why I'm trying to explain this. Right to remedy, what they are trying to mean for the breach of the covenants of the contract, okay, under any law, okay. For that, if the terms of the contract is breached, then the right to remedy is to give a claim, correct? So that means that compensated. I'm saying that not that compensation where we get compensation under statutory provisions. I'm not talking about that compensation. I'm telling the general meaning of the compensation. So here, how it differs only I'm saying. That's why I'm trying to understand the difference between the A and B. A itself is right to payment. My point, the moment someone is breaching the contract, so I get a remedy. I get a right to remedy when somebody breaches the contract in the form of right to payment. Do you agree?
It is a two different contexts, sir. That is why they are given a separate class.
I wanted your input. That's why I don't want to say that everything is one and the same. It's a different. That's why I wanted your inputs.
Yes, yes, it is different.
Yeah. Can we see the scenario? Which scenario will come in B?
In the B, it will come only that when the claim is not crystallized. It has to be crystallized.
No, there should be a breach of contract.
Yeah.
There is no crystallization question is coming now.
In the A, it is crystallized.
It's a breach
Sir,
of.
in case of A, sir, in case of A, that is A is for the kind of any general purpose, any if you supplying any material or service, that is fall under A and B. Suppose you have to be make a contract in 1 year, and due to there is a contract of 1 year you have to complete, and you have taken 2 or 3 years. That is a breach of contract. So that's in the it will fall in second category.
Okay. So now, okay, I'll give one more example. So we'll discuss whether this suits or not. Right to remedy in case of home buyers. The builder promises the home buyer that he will deliver the flats within 36 months. So he fails to deliver, and the company goes into insolvency under the IBC. So here, can we say that as per the contract that he is supposed to deliver the flat to the home buyer where he breached the contract? So the remedy is that in the form of payment, right? Then the home buyer gets the right of claiming or right to payment in the form of claim. Can we bring this scenario into class B? Or this scenario will fit into class A itself?
So it will be in the B, and ultimately it will shift to the A.
Okay. Because here, if you see, the money is paid, but here the home buyer, of course, we have another judgment also, purchasers also covered, that we will be deliberating, that purchasers also covered under the operation creditor. So here, if you see the buyer, here buyer pay money to the builder for delivery of the flat. The builder fails to deliver the flat. So what we are discussing here, that the claim that can be made by the buyer of the flat. So whether the buyer will come in class A or class B. That's my point. Where he'll be more, will fit into that. Which category?
You'll be fitting into B.
Correct, exactly. Not in A.
Not in A, because there is no right to payment.
Exactly. That only I said.
There is no right to payment. It's
only I
performance of contract.
Exactly. So this difference that we need to understand, when the covenants directly gives right to someone to payment, that differs from right to remedy for breach of the contract. So both are different, not one and the same. Here under class A, right to payment directly comes. Whether or not such right is reduced, need not to be in writing, need not to be fixed, or need not to be disputed or undisputed. It can be anything, but there's a right to the payment directly. Whereas in scenario B, the right to remedy for breach of contract, it's not coming directly. It is a right arising out of a breach of contract. What is a breach of contract? Breach of contract is failure in delivering the flat on time, or even failure to deliver the flat itself. Even the same the case when goods supposed to be supplied with, not supplied. Whether it will come in A or B, goods supposed to be supplied, not supplied.
B.
B.
So that means, yeah, that means wherever the right arises directly for the payment, directly to make a payment. In fact, where I would say rather right to payment more will arises in a financial creditor category. Do you agree with that? Right to payment directly, more than it comes to operation creditor category, it comes to the financial creditor category where there is no supply, there is no providing of any services, any materials involved, where the time value of money is involved and directly the payment and right to payment is arises there on demand. So,
sir, it is the definition is silent. So just drawing the inferences by the wording of the this statute, I don't think it will be correct. It is just silent and it includes, and 3A includes
yes,
B.
yes, no doubt, no doubt. I'm saying right to payment directly it hits that, whereas in case of operation creditor, that the only circumstances only decides based on the contracting arrangements, based on the transaction only it decides. That only I'm trying to say here. So A and B, based on the scenario, based on the situation, scenario, and transaction nature, we have to see whether it fits in A or B. Whereas in case of financial creditor, it appears directly, it comes right, in a class A scenario. That's what I'm trying to say. But both the scenario it are open to both financial creditors and operation creditor. But the claim word has to be understood properly. That one, it is a right to payment. Two, it is right to remedy for breach of contract under any law. This alone we need to understand. I'll move on to next one. Why I wanted this in our subsequent deliberations. You will understand why I discussed that like this. Because when we deliberate the cases, you will understand the difference how the court has observed and what kind of order they passed, on what understanding they passed the order. That's why this particular point I was drawing your attention on that. Okay. So what is debt? Debt is a liability or obligation in respect of a claim. Again, so basically there is a financial debt and another category is operation debt. So first of all, to get a right, okay, to get a right to file a claim, then basically it should be a debt, either financial debt or operation debt. So what is debt? A liability or obligation in respect of a claim which is due from any person, includes a financial debt and operation debt. Here I wanted to again understand. Please note that I wanted to understand so that my knowledge also improves with that. Please don't think any of my deliberation I know the answer and asking you. No, because every day we are evolving and every day we are getting new things to going in our mind. So I wanted to understand better so that the scenario which is not coming in mind, at least I can take inputs from you and try to see that whether these scenarios also can be covered under in the within the meaning of the definition and in the future our transactions. Yeah. Now, a liability or obligation in respect of a claim which is due from any person and includes. So as it is financial debt is included, operation debt is included. What any other debt is they are trying to cover? Any other debt. Because they themselves is covered both. And predominantly insolvency bankruptcy code completely revolving only on these concepts called one is financial debt and second is operation debt. Is there any other debt that they are trying to say in definition 311? Any point on this other than these two? Any other category of debt? Can anyone share your thought on this? Anything is coming in your mind other than financial debt and operation debt? A liability or obligation in respect of a claim.
Due to employees, dues to the employees.
It anyway is covered. Anyway, it's
Dues to
covered.
the employees.
Yeah. Anyway, it's covered under. See, you are trying
Contingent liability.
Anyway, it's covered as admitted liability only. See, in section 53, as you say, the secured creditors and workmen, then it comes to
CRP cost.
Statutory dues.
It is there. It is there. So
Statutory dues.
Yeah.
Income tax, GST, all this.
All are coming under operation debt. Yes, it's coming under operation debt, right? So
Yeah.
there is a one category of debt called financial debt, the another category of debt called operation debt. Is there any another third category of debt there in the insolvency code? That alone I wanted to understand.
No.
Okay. So that means the debt also is widely defined to mean a liability or obligation in respect of a claim which is due from any person and includes. So they mean to say that there can be a debt other than financial debt and operation debt. They are trying to, by articulating this way, by defining this way, because this is a code. We can't, not just like a law, we can read and understand, okay, fine. It could be understood in this particular way. It's a code where it is a torch bearer for the entire financial failure of the corporate in our country. So that means when it is a guiding principle for the entire financial failure in the country, when code gives wide interpretation, then it will be better. See, that means then we have better footing where we get a better chance to interpret and understand and bring many aspects or many new aspects. I'm saying whatever is already codified, I'm saying what is not already codified also can be brought in the category of debt other than financial debt and operation debt.
So far as it has not yet come into picture, and legislature did not anticipate while drafting this clause that whether any other debt will come into picture or not. So far as it has not come.
Yeah, exactly. That only I'm saying. See, that's why I'm this particular two definition I wanted to deliberate, because this two definition is very important in any of the matters in court. The judges immediately going and see what is defined. What is the scope of the terminology called claim and debt? That only they are going and seeing. Then only they are coming to the operation debt and financial debt on that. So basically, the code has to permit for the judicial authority or anybody for this matter to travel. Of course, the Supreme Court has got power on our Honorable Supreme Court. They can review it and see that they can give a different dimension, but still the code itself can give a leverage for us to interpret and cover, and it will need not to look for the higher forum code to clarify anything. We can move on with the definition, understanding definition in a proper sense. Fine. Now coming to this operation debt. See here the claim, we will deliberate each and every claim by workman and operation creditor, financial creditor, and one by one even statutory authority. There are so many orders have come in the claim. Okay. So, but before that, what is the fundamental thing that we need to understand? So here, the operation debt, a claim, again the claim. So basically, it should qualify as a claim. Then only it become a debt, which we have seen also. A claim in respect of a provision of goods, services, including employment, or a debt in respect of payment due arising under any law, or as it is, we all know this thing. Here, recently you must be knowing that there was an order passed by court that the purchaser also covered. Anyway, we'll be deliberating that case law also in the session. So here in this purchase, purchaser also is covered according to the order passed by the court. But whereas it only says in respect of provisions of goods and services, including employment or debt in respect of the payment of dues. Here the word debt is again coming. So as it is, the definition itself is an operation debt. So debt in respect of payment of dues arising under any law. So that as long as it is coming within the category of operation debt, then it is an operation debt. That's what it is trying to conclude. Okay. Coming to operation creditor category, and just same thing, the operating debt is owned, that of course we know legally assigned and transferred. What is legally assigned and transferred? Any view on this? Is there any process is codified under insolvency code or any other law? Any idea from members, from participants? Legally assigned or transferred. That means there should be an assignment date. Is it so?
Yeah. In case of insurance, if you are transferring some insurance to another party, so there is some policy you can assign, or there is maybe a decree against passed against the party, so you can also claim from.
See, can we give an interpretation to this, saying that the word legally assigned is nothing but a person who is assigning have a legal right to assign? Can we say this? Can we understand?
The assignee will be step into the shoes of assigner, and the legally assigned that also by operation of law.
Yes.
Certain debts can also arise out of operation of law.
Yeah.
Transport to ERCs.
Yes.
Transport to ERCs.
Okay. That means the assignee will step into the shoes of the assigner. Legally, he should step into the shoes of assigner. So that means they should have a legal authority to assign the debt. Can we understand this way? One should have a legal authority to assign the debt. Then only it is legally assigned.
Can you give some other? You can give some example.
I'm just saying. The legal authority means, see, the bank is assigning the debt.
ARC purchasing the loan.
Yeah. The banks are assigning the debt to ARC. So that means, that's what I'm trying to understand the language legally. Why the legally? See, it has been assigned or transferred. Okay, but probably they mean to say that legally is nothing but, we can try to understand the person who is assigning should have a legal authority to do it, and the person who is
legally means, sir, here the term in my view, why legal word has been used, it should be a legal debt. It should not be like a other debt. The debt which is enforceable by the law.
Okay, so you are telling another perspective. Okay, illegal debt. That means that it should be legally enforceable debt. That's what you are trying to say.
Yes.
Okay, then it can be legally assigned. Fine. So this particular word is why I was keep emphasizing this particular thing. So because we come across a lot of assignments. Actually, no, that when COC is formed by IRP, that time during even RP during the CRP time. So the bank assigns the debt to the ARCs or another person. then in which case we need to know what are the papers and documents that has to be supporting the legally support the assignments, right? So for that, but there's nothing provided in the code per se. Is there anything under Transfer of Property Act that provides? Is there anything under contract that provides?
Yeah,
What
will
assignment should
that transfer of the property or debts or whatsoever through will, through gift, through lease?
no, that's for property.
Property can be transferred through will.
Yeah, that's for property. Here,
But sir, it has to be properly stamped and it has to be registered as per Registration Act.
No, no, it's not required. Will
It is
is not
legally
required to be
enforced.
registered. It is not required to be stamped also. It can be on plain paper. Nothing is required. Only two witnesses are required. That's it.
that's okay. Let's not go into that aspects. In fact, under section 17 and 18 of Registration Act, whatever under section 17 of Registration Act is compulsory registrable, it has to be registered. If it is under section 18 means optional, means we need not to register. 1, 2, the stamp duty, whatever it has to be levied or leviable in any of the instrument, that has to be borne by the instrument. It can be on the plain paper as long as it is only a MOU, which is not compulsorily registerable, or which is not leviable, falls within the incidence of stamp duty under the Indian Stamp Act. Let's not go into that. But here, whatever legally has to be stamped, legally has to be registered, it has to be done. Otherwise, it will not sail through in the court of law for the evidence. That's what the provision, that's what the law make it mandatory, a certain instrument to be stamped and certain instrument to be registered compulsorily under Stamp Act as well as Registration Act.
I think in nutshell, it should be the document or instrument which is admissible in the court of law. That's it.
Yes. I'm saying only which are falling within the schedule to the Indian Stamp Act. Okay. So this is what, anyway, fine. Enough we have deliberated. Now, I think I'll just take you through certain points. Then I will move on to next. Okay. Now claim, filing of claim. You know, Regulation 7 talks about claims by operation creditor. Regulation 8 talks about claim by financial creditor. Regulation 8A, claims by creditor and a class. Then 9 by claims by a workman and employee. Then claim by other creditors. This is what the claim related provisions. I will take you through. Just a moment. Yeah. Now coming to yeah. So these are the points, important things which I wanted to tell you. See, if in case of CARP, if you see that the submission of proof of claim, what is the timeline given? See, in case of IRP, within the stipulated time they have to give to the IRP. What is the timeline given in that? Before 90th day of insolvency commencement date. I know earlier the provisions were different. Now they changed as 90 days before the 90th day of insolvency. Here the question comes, the claim which has not received within 90th day, whether the claim is acceptable or not. I have cases are there to discuss, but still I thought I can take your inputs before going into that.
It varies from case to case. In case of home buyer case, court has taken very liberal views that RP should allow such claim in case of home buyer because they are living in various states, other states also. And in certain cases also that RP or IRP needs to take approval from AA before admitting the claim. So there is a judgment of Justice M.M. Kumar, Principal Bench, that even if before approval of resolution plan, RP should admit this claim. So, and there are also divergent judgment also. that RP should take approval. So it varies from case to case. There is no thumb rule about this.
Oh, then okay.
Only except before approval of resolution plan is the thumb rule here.
Okay. So
But in case of liquidation, it is not allowed till only 30 days is allowed.
In liquidation, it is 30 days. Beyond 30 days, it is to be accepted only through approval or through order by the AA.
Yes.
That is, the appeal has to be filed.
Yes.
Now coming to your point, see.
But the power to accept these claims after certain period, the RP cannot take a view on his own, sir.
Okay, yeah. See, I'll show you number of cases, as our friend said. I will show you the cases.
But in that case, the party has filed a claim.
My friend is what our friend is saying. See, when we are resolving the claims stating that they are time barred, the NCLT, honorable NCLT is directing to admit it. When we ourselves are admitting, then there is an issue there. So ideally, the RP should not admit the claims after a certain period. Allow the claimant to reach to NCLT and wait for an order from NCLT.
There is a Damodar Valley.
Hello.
There, yeah. Tell me.
Sir, I want your views because there is a different views coming from our professional associate.
Yes.
So my question is that there is some question, some cases there that RP because case is different and there are in the Supreme Court or NCLT there is a different case in subject matter. So there is some views is there कि RP should not be should be go to the adjudicating authority and take the direction from the adjudicating authority here in such cases. If there is some not clarity is there, and sometimes if you are going to adjudicating authority saying to the RP, you are wasting my time. Why I should not put one penalty on you? Because you don't have any legal opinion and you are coming to me, just give me 50,000 rupees. So that is also case we seen like that. What should do because every adjudicating authority can be judge is different in different NCLT.
See, yeah, I think good. See, that's what I wanted to deliberate because here, as our friend said, that we can't take something as a thumb rule. That's what our friend shared now his view. But here, when there is no thumb rule, how to RP and liquidator move forward? When the claim comes after the statutory period, there is no thumb rule. Let's deliberate and find out. That's why I'm putting across this question. Because I also know all the judgments. I also read all the orders, what you have gone through orders. Okay. There are so many orders are even now. In fact, recently in June also, Honorable NCLAT has passed one order. Okay. And reversing the order of the NCLT. And there are so many orders are coming up. But still, there is no thumb rule. Can we, do you accept that there is no thumb rule in accepting the claim?
Regarding CIRP, during CIRP, yes, if before approval of this resolution plan, RP can admit. Prior to approval of AA or without approval of AA, depending upon case to case. Yeah. But the prior approval of resolution plan, RP can admit.
So that's based on the orders, recent orders, even sometime back also order 2019 itself one order came. Then 2021-22 there are a lot of orders of Honorable NCLAT as well as even Honorable NCLT. So based on that order, you are trying to conclude that till resolution plan is approved that we can take it. But the regulation still stands with 90 days, correct?
Yes. Because law is still evolving and certain decision has to be taken through judicial precedent.
But at the same time, the RP and liquidator should not turn to fault also, no? Should not get into fault by following some process which is not written. But that means he has to be very careful, the RP or liquidator, that whatever the recent verdict, the position of the recent verdict has to be followed or adhered with. Is it so?
Yeah, very correct. Recent order must be seen. It is not like the one case is fitting in the same another case.
Exactly. That's what I'm saying. So
Correct.
now as a RP or as a liquidator, now we are becoming duty bound now to see that more than a regulation which is providing a 90 days timeline to accept the claim, but now we are obligated to see what is the reason order, and as per the reason order what needs to be followed by RP and liquidator, that we have to see and move on. Correct?
That's what also observed by the Honorable Supreme Court in the review petition filed in the Vidarbha case.
Yeah.
When it was filed, the Supreme Court has also observed the same thing, that it varies from case to case. It doesn't mean that government department is secure creditor in all cases.
Yeah, correct. No, in that recent judgment also.
Yes.
That they covered state government also secured creditor, but that must be applicable to that particular scenario and that particular case. But not all the state government can be treated as secured creditor, right?
Correct, correct.
Cannot be, right? Cannot be. So like that, there are number of cases which are coming up. Now, 90 days timeline, do you feel that this 90 days timeline is not having relevance today in the rule book? 90 days timeline is...
To some extent, yes, sir.
Holistically, RP has to follow 90 days. To save his skin, he can also approach to A for taking approval beyond 90 days. Before approval of resolution.
So what I am trying to say, this 90 days, what is then the rule book is losing its relevance in certain cases, correct? Certain times. Certain
Yes, sir, even the 14 days is also losing its importance.
Every timeline I'm saying. I'm not telling 14 days, 90 days, even liquidation, going on appeal. Okay, so cases are there for every scenario. So now, since we are into this page, I'm just trying to understand. So I just wanted to know, we are all in the same understanding or not? For that only.
Sir, one point of consideration is if it is in the case of a financial creditor, for example, a person who has lent a loan to a company, he has to file his claim within 90 days. And if he files a claim after 90 days, you have no right to accept it. One thing. Second thing is the judgments have been in that favor only. Only in the case of home buyers, where this 90 days period is being ruled out. They say the claim is there and it is for the RP to decide. And one more thing is, he has to give it in writing that he is not accepting his claim because it has gone beyond a period of 90 days. Even in the case of claim admittance, you have to tell the client that for such and such reason, I am not accepting your claim when it is beyond 90 days. And if he has filed it after that, and if he goes to the court of law, normally in the case of home buyers, they take that into consideration and allow the claim. But in the case of other financial creditors, it's a judgment to be taken on record.
Correct. But as we were deliberating now, that we have to see the latest position before proceeding in treatment of claims. Basically, that's what I wanted to bringing on.
Sir. Simple point of consideration for an RP.
Yes. Yes.
90 days, if it has crossed, just simply send a mail that you have received your claim after 90 days. I'm not in a position to accept or reject your claim. Because it clearly says 90 days is my deadline period and all orders are in this favor. In one of the cases of NCLAT, the RP was pulled up. Why did he accept his claim after 90 days?
Yeah, one of the matters, order has been passed.
Order has been passed.
The authority of the RP.
So we have to be careful. Let us go by the rule book and say that your claim, we are in receipt of the claim. We are not in a position to take it on record. You have to say it is just taken on record. regard to the admittance of the claim, it is beyond 90 days. Simply you have to say that and complete the clause. Complete the matter.
Agreed.
Yes, sir. Agreed with Shivaramanji.
Mr. Pramod has raised your hand, right?
Yes. Sir, good afternoon. I want to ask one question, means one query about this home buyer case, where A Limited and B Limited are the holding and subsidiary company. Holding company is under CIRP, and subsidiary company had sold some flats. So, as a home buyer, whether IRP should consider the claim filed by the home buyer.
The claim, the home buyer would have filed the claim to subsidiary company only, right? Because project in subsidiary.
Subsidiary is not under CIRP, holding is under CIRP.
Then both are different company. Then why you need to file a claim?
See, ultimately,
the subsidiary is self-sustained.
Ownership of subsidiary company going to the holding company only. And when CIRP is going on, ultimately their assets are also going to be liquidated somewhere.
Is the legal position is very clear as on date that the moment the holding company comes into CRP, all the subsidiary also comes to the CRP. Is it so? Is the legal position is so?
No,
let us conclude that, then we will come to discussion. Is the legal position, because let me understand. See, I'm also writing books. I can't write simply different things, no?
Solomon and Solomon.
No. You leave the Solomon, that's old age case. Still we are discussing Solomon only. But let's try to understand now what is the position. Since the question we put on the table, I'm just asking you this particular point, whether if the moment the holding company comes into CRP, whether is it the responsibility, duty of the RP to bring in within the basket or net all the subsidiaries of the holding company. If yes means we will then move on. No means we will move on in different line.
It's no.
No. Then the question what you asked, no, Pramodji has asked. Now, the home buyer has to give a claim, need not to give a claim to holding company when subsidiary company is very much active. I agree, the subsidiary company is nothing but it comes in the books of the holding company, no doubt. Okay. In the financial statement of the holding company, the subsidiary company will be in the form of the investment. That's what your question. That's what the whole confusion actually in the arrangement. Correct. Because when the RP is legally obligated to take over and run the company or liquidate the assets of the company, he has to see all the line item of the balance sheet, right? In the asset side, correct? Asset, fixed asset. Then in that case, when the question comes to investment, whether RP is under obligation to take over subsidiary company also, running company.
Not at all.
Correct?
Not at all.
Then he has to spare the subsidiary company, focus only on the holding company as long as subsidiary company is a legal entity. It's legal entity and it survives on its own, though the owners are the though the owner may be the holding company, but still being a legal entity, subsidiary company is distinct entity. Right?
RP should reject the claim if he getting the claim from the home buyers.
That's what I was trying to tell you, that if the subsidiary company is self-sustained, if they are in a position to execute the project and deliver the project, where is the question of claim comes?
Sir, with due respect, I am not agreeing that whether sustainable. Company is sustainable, not sustainable, working, not working, doesn't make any difference with respect to the subsidiary company.
No. That's what I asked that time. When I asked question, you were not telling anything. I asked this question, then you have to answer to that question. If holding company comes into CARP, whether the RP has to bring all subsidiaries under the ambit of CARP. Please answer that question. Then you can give your points.
No, sir, it cannot be, because this all being a different entity.
Exactly.
And it is.
Exactly.
No, correct.
It's a different entity. Fine. Tell me, sir. I think a friend have a different view. Let him deliberate. Let him also give his view. Yeah, you can share your views. No, See, because we need to understand, it is not that something we are deliberating and going away with the whole thing. We are going to practice. After the session, the scenario may come to any one of you.
Sir, even the IBC code recognizes the distribution of that parameter of taking of equity shares or not, of the relation being a holding and subsidiary company.
Yeah, I agree. But what is the position today? That's what the question why I put today is the one is it if when the RP has got a responsibility and obligation, is duty bound to liquidate the assets of the holding company, whether the investments which is standing in the books of account in the financial statement of the holding company also comes within the ambit of liquidator to liquidate.
No.
Liquidator needs to dispose of only the investments.
Yes.
Nothing to do with the operations and day-to-day things regarding the subsidiary company. He will only dispose of the investments in that subsidiary company as an asset. That's all.
Okay, that means that investments can be sold or can be realized by the liquidator, finding a way out for that. That legal entity should continue.
Yes, yes.
Now, our friend's question is that whether the home buyer of the subsidiary company can file a claim before.
No, not at all. Not at all.
Liquidator, no.
No, big
I
no.
think, hope everybody is on the same page. Otherwise, we'll deliberate. If you have a point, you please share it. No, nothing wrong, because we need to have answer to move forward. To deal with the RP, IRP or liquidator, everybody need answer. It's not that today we are discussing something and doing something else. No, because we are answerable for the entire stakeholders and authorities, everybody. So we have to have a safer view. We have to take a safer view and also move forward as per the code, as per the orders which is passed. I think the answer, Mr. Pramod has got answer, I think. Okay, so he was only putting this question. Okay.
Oh, audio, video tools.
Sorry?
No, sorry.
Participant, I think you can mute if you're not having any questions.
So, in case of going concern sale by liquidator,
okay.
So in such case, so he have to be manage everything.
Sorry, what are they? Can you comment the question?
I am saying the liquidator in case of going concern sale.
Samir Bhattacharya, please mute yourself. Samir Bhattacharya.
Yeah, please come in, please. Yeah, can you please repeat the question?
I am saying in liquidator in case of going concern sale as a liquidation in case of liquidation. So there is so he have to manage everything.
Sorry, I'm not getting the point. Some disturbances keep coming.
Samir Bhattacharya, mute yourself. Somebody, the whole. Sir, please unmute yourself.
Yeah. I think, okay, I'll move on then. Till I think till our friend, he is not. Yeah, tell me.
Hello. I am saying in case of going concern liquidation, because you have to say liquidate the company as a going concern. So in case of the liquidator have to do many things.
What many things? In fact,
You have to manage like a RP.
no, see, it's not like that. It is only a, I think it is not something related to today's topic, but still, uh, the question is asked. I am just putting in a crisp answer in a crisp way. See, this liquidator is given a duty to follow Regulation 32 while doing an e-auction. Regulation 32 talks about sale by, as you know, that standalone basis and slum sale. A to F is there, correct? So liquidate, it is only for the purpose of coming out of the e-action. Section Regulation 32 gives all the option from A to F. So it is only for the purpose of making sale. The liquidator should endeavor to sell the corporate debtor or business of the corporate debtor as a going concern, because after liquidation comes, it is no longer going concern, but when it is sold, it should be sold as a going concern, so that the buyer will get the entity corporate debtor as a going concern in the eyes of law, not that running company. So running company, it's not that what it is contemplated under Regulation 32 of liquidation. Regulation, it is only a going concern in the eyes of law, so that the buyer will try to enjoy the benefit, and he'll be, will not be struggling to bring the operations of the company when the company is sold as a going concern in the liquidation.
Suppose that the company is not into not a going concern, that all the operations are shut for, let's say, last for 3 to 4 years.
Any company is that way only, but that's why I told you that I don't understand the reading of, if my blind reading goes in the regulation, it says it should be sold as a corporate as a going concern, business as a going concern. But till then, it would not have been run as a going concern by the liquidator. But for the buyer, that they have to receive it in the hand of, it should go in the hand of buyer as a going concern, right? Not by just by selling the asset, because the idea here, as you know, the Supreme, it's very clearly stated by, observed by Honorable Supreme Court, that the object of the code, if you see the preamble does not have the word called liquidation. Anyone can even see now, the preamble of the Insolvency Bankruptcy Code does not provide for the word of liquidation. Okay, so therefore, what Honorable Supreme Court has observed is that since the object of the code itself is not the liquidation, why the company should be killed in the name of liquidation? So try to come out with some scheme. So that's what the process, as you know, that Regulation 2 be introduced, where the scheme can be given, within 30 days. All that is now is in practice. Now after that, the liquidator has given another option under Regulation 32(1)(e) and F to sell the corporate debtor as a going concern. So all this is just to see that the company is not killed. It is given as a going concern in the receiving hand, not as a running condition. I don't understand that way. That company should be given as a running condition. Okay. You are muted, Mr. Rajkumar. I think you are muted.
I'm so sorry. By way of selling the company as a going concern, which includes only assets, not the liabilities.
No, that is there's a different set of cases again there. I think we need to have a separate session.
Okay.
What corporate data sale of corporate data is going concern. You ought to tell our organizer to have a separate session. We can talk 2 hours that alone. So much is there to discuss in that aspects. Selling the corporate data as a going concern itself is a bigger concept, an emerging concept, and there are a lot of judgments for that also. And I think we need to understand more. If you have anything is there, you can come. One session is over, you can put your question. I'll try to throw some light on that. But now, without deviating much on the topic, let me go back to the claim. Okay. So now, the claim, as I was referring, that it should be given within 90 days time. So our friends were sharing their thoughts that it need not to be in 90 days, can be after 90 days because of the various orders and judgments are passed. Of course, I'll be taking you through all the orders little later in the end of my slide. I'm keeping it. Now, taking through regulation 12A of CRP, again, the updation of claim can be done. Is another interesting thing. So, a creditor shall update, okay, his claim as and when claim is satisfied, immediately it becomes the duty to update. So, this is another important aspect that we need to understand. We were discussing about the verification of claim. Here, within 7 days from the last date of receipt of the claim, it becomes the responsibility of the IRP to verify or RP to verify and maintain the list of creditor. And once the list of creditor is prepared, okay, and which carries the name of creditors along with the amount claimed and the claim admitted and security interest. Of course, we will deliberate more on security interest. That's very important topic. I will take you through that particular portion also. Security interest. The list of creditors shall be available for inspection by person submitted proof of claim. Available for inspection.
Actually, sir.
Sorry.
Can you share some claim? How do you maintain the claim in practical way in your Excel or like this? There is a format you are maintaining that.
The format you are saying. Format. You are telling the claim format.
You are saying that there is so many claims is there, and you are collecting that claim. There is a creditor financial operation. You are making some sheet.
Yeah, I made claim. I have prepared all that, but it is, of course, I have uploaded the website also. It is there, but as of for this purpose of conference seminar, I have not done the format. I don't have ready-made format right now, but it is a basic information that you can. I can show you also at the end of the thing what are the basic things that you can cover. Okay. End of the session, I will show you what are the basic things that can be covered in that. Okay. Now, these are the parameters that I was discussing. No, the list of data shall be made available. Of course, recently should be filed on electronic form also of the board for dissemination on its website. Now, coming to that, I wanted to take you through the security interest. The word, what is security interest?
I have one question regarding claim. Can I?
Yeah, please.
It is updation of claim. Suppose only one claim is updated. Do I have to update the whole list of claims on IBBI site, or only one can be done?
That one list, in that list, you have to update one claim, or that list cannot be this thing, then you can.
There are 50 claims of different categories, and in one case only OC is changed, suppose. So whether I have to upload all the lists again in all categories, or only that particular, because the on IBBI site it is mentioned that way only. Now I have to fill up all the data, I think.
Yes. Looks so. It should be updated that way only.
Okay.
Regarding claim, I also have one question. Suppose
please.
if financial claim comes up, financial creditors claims comes up, does it mean that the COC will be changed in terms of the percentages which they have, and also a new member added?
Sorry, financial creditor?
If a financial creditor's claim gets accepted within 90 days,
okay,
but COC is already formed,
yeah,
so he will also, that creditor will also get added into COC, and the percentages assigned to earlier COC members will get adjusted accordingly.
Yeah, it has to be, no, it has to be adjusted. The moment we accept the claim of the financial creditor, then he becomes after he becomes part of the COC member, naturally the percentage will undergo change only, as and when financial creditor is added in the COC in the committee.
Thank you.
Yeah, it has to be, because the law provides for that. Subsequently, after forming the COC, also the financial creditor can be added as a member of the COC. Then accordingly, it will undergo the change also. Okay. Now, again, coming to the determination, I'll take you through that security interest. That's we will discuss more in that aspects also. In fact, I need your inputs also. We need to deliberate that. Before that, I will finish up the claim part in the CARP. See, determination of claim, again, if you see here also, the prerogative is given that the RP or liquidator, means the RP or IRP or RP, he can make a best estimate of the amount when the claim amount is not precise due to any contingency or any other reason. So that means if nothing could be frozen in the hands of the RP and IRP, then the regulation gives power, or regulation gives a free hand to the RP or IRP that he should make an best estimate of the amount. He should not keep it open just because of there is lack of clarity. Okay, even if it is a contingency or any other reason also. So that means it gives free hands to the IRP and RP to make, and it is casting a duty upon IRP and RP that he shall make a best estimate of the amount of claim based on the information available. Same way, whatever the claim, additional information is coming, he should keep changing it also. That also, it making it mandate. I'll take you through this one important concept. This one I was telling. In fact, as soon as we give a public advertisement, announcement, we need to state the last date for submission of claim. Of course, I was showing that the duties of IRP, the important duty is to receive, collate all claims. Same the duty that is given under the code to the RP also. So to receive, collate all the claim, and here the adjudication power is not there, as we were discussing little before. Just a moment. Yeah. So is make it clear, section 18 and class B make it very clear that the power is given only to collate. Okay, receive and collate, and he has to verify. Of course, the orders have come passed by courts that the IRP RP should verify it, but they don't have power to adjudicate, but they have to verify it, and the power of adjudication is only given to the liquidator. Okay. Now coming to
sir, can I have one doubt here?
Yeah.
So far as verification of claim is concerned, so how to communicate this to, whether it has been admitted fully or it is still under verification? If it is under verification, then how long keep on giving that fact as under verification column?
No, it cannot be for lifelong.
Yeah.
Lifetime of the company, it cannot be under verification. But see, first of all, it is a duty of the RP and the liquidator to make sure the claim is, it's frozen. Okay, and if it is under, for want of some information or some, that's why I read out the provision just before. That the law makes it code makes it very clear that in case of any contingency or any other reason, it gives a duty to the IRP and RP to make sure that IRP or RP making a best estimate and completing the process of verification. Okay.
Again, here comes the adjudication, sir.
Yeah, it cannot be under verification for a long time. That's why the best estimate provision is there under the code.
What is meant by adjudication of the claim? Miss, whether it is correct or what do you mean with that?
Adjudication of claim is, adjudication is fixing the value, means amount, the claim amount. That means deciding the claim amount, whether right or wrong. Okay. So that's the adjudication.
Actually, adjudication it is the judicial determination of the claim.
Sorry, can you repeat?
It's me, madam asking the judicial adjudication is the judicial determination of the claim.
Yeah, see, this adjudication by liquidator that madam was asking. So it is only the duty of the liquidator that the liquidator should receive the claim and adjudicate the claim. which is not the duty of the IRP and RP. That power is not given to IRP and RP, whereas the liquidator is obligated, duty bound to adjudicate the claim. But it's not the judicial and otherwise, it is by the adjudication by the liquidator, which the code empowers the liquidator to do.
So what is the thin line of adjudication and collating the document, collating the claim rather?
That's what I explained now. The adjudication is should be that the amount, whatever the claim amount, the decision on the claim amount should be adjudication. Okay, decision on the claim amount. Whereas IRP, RP is not given that authority to decide the correctness of the claim amount. Okay, admission and rejection power is not given to IRP or RP.
Yes, that's the point.
Admission rejection power given to the liquidator. Okay. Now coming to again the claim definition which we have seen. Secured, the word secured or secured, again everywhere it is appearing. So I wanted to know what is secured, because when I take you through section 53, it is giving the waterfall mechanism of the first line item is that the first priority is to the insolvency cost and liquidation cost. The next one is that secured and the workman. What is secured? So something secured under the Companies Act will be treated as secured for the purpose of insolvency court, or something secured, I'll put it this way, something secured for the purpose of company insolvency code will be deemed as secured for the purpose of Companies Act. So I need to understand this, and I think the participants can share your views. What is secured?
Sir, it emanates from the Companies Act, where like the charge is required to be registered. That's how the security interest is created in the eyes of law.
But is it the charge registration is a prerequisites to deem it as secured interest for treatment of claim? For treating a claim as a secured one, whether charge registration is a prerequisite?
Yes.
Of Companies Act?
For financial creditors, yes.
But here, if you very closely, if you read this, of course, without getting into right or wrong, I'm just reading out that. See, security interest, what IBC says, it differs from Companies Act under section 77. I'll show you that also. So here under insolvency code, the security interest means right title interest claim created in favor provided for secured creditor. Okay, who is secured creditor? A creditor in favor of whom security interest is created. So again, we are coming back to same security interest only. Secured creditor by a transaction which is secures payment or performance and obligation and includes mortgage, charge, hypothecation and assignment and encumbrance. So do you mean to say now, since the security interest definition includes a charge as one of the element, can we say that the charge, registration of charge is a prerequisite to deem it as a security interest of property? To say a property has got a secured interest, okay, a creditor has got a security interest, can we say that the charge registration is a prerequisite for that? Because the definition here read, of course, still there is no clarity, but I'm just taking your input. I
have a question here. Can I ask you?
Yeah, please.
See, in the case of home buyers, suppose there is an agreement of sale between the builder and the buyer. Can it be included under security interest?
That's what our friend was saying, that section 77 Companies Act, it should have, the charge must have been registered to deem it as a secured interest.
But once in the IBC, these guidelines have been given, we need not go to the Companies Act and all those things, I am sure.
But the security interest, what is secured, the word, that's what here, that see the word so far as how the security is created, how a person becomes a secured. Let's try to understand that. Then Probably we may understand what is.
No. See, there is no problem and there is no doubt regarding the security creation, etc., etc.
Yeah.
Because everybody is stalwart in that one and everybody knowing.
Correct.
But here loose ends are only regarding any other agreement or arrangement securing payment or performance of any obligation.
Correct.
In the case of house buyers, a performance obligation is there that after within 2 years, 3 years after payment of this EMI, etc., we will hand over the house to you.
Agreed.
So therefore, whether the home buyers are coming under security interest or not is the question.
When the home buyer comes under security interest, they become a secured creditor, is it not?
Sir, basic concept of a security interest is that it should be live and it should be decipherable. For example, a property, it should be decipherable. That is, it is in existence. What is not in existence cannot be a security interest. First, let us have a clarity on that point. For a future transaction which is going to happen, that cannot be a security interest in the eyes of law. A security interest is something that is found and which can be taken up when you want to realize a payment. This is the basic.
What about performance of obligation?
That is what performance of obligation is. Not that is the security interest. That is the flat. Is it constructed and fully given? That's a basic question which we have to answer.
The security is constructed, this question will not arise.
That is what I'm saying.
They will be in the process.
No.
They will be in the process. But one thing is
completed.
I think. See here, I think we need to understand what you are saying is again that the understanding that one is getting when we read it. So here, unfortunately, we are not in a position to conclude anything. The reason being here, the court also, even in Pioneer, urban Pioneer, the court has not come out with a clarity that home buyer should be brought under the secured creditor. Problem there also, if you see the entire judgment of the Pioneer, urban case, Pioneer, where there also they left it open. Okay, that even the home buyer who has got their UDS registered, there also the Supreme Court, Honorable Supreme Court never ordered. If they would have ordered in that matter, then I think it would have put a full stop to every deliberation what we are having. That order also it was open and they kept it. They only recognized them as a financial creditor. Okay, No, you are muted. You are muted. You are muted. You are muted, sir. You are muted.
You mean myself?
You are mute.
Yeah. The point of consideration in the case of urban, whatever the case is, the judgment based on that only the financial creditor definition was changed, where the home buyer was brought under section 58F. Before that, there was a point of consideration whether they should be considered as financial creditor or not. That's a basic consideration. Second thing is, for example, I have come across cases where security interest is being created and ROC charge is created on the property for the loan given. How can there be a security interest which is not in existence? Can a charge be created?
I'll explain you now how it happens, how it operates. See, now what happens generally, the corporate debtor, they are giving a land to the bank and taking loan. And they are creating a charge under section 77 in favor of the bank which is lending to the corporate debtor. So already the charge is created and registered with the registrar of companies, and the security interest is already created in favor of the bank which is lent a loan to the project. Okay. After the land is charged to the lender, banker. Now, when the banker is already having a security interest towards the land after creating a charge in the Section 77 of Companies Act. But same property, when it is given to the, or agreement is entered with the allotee, so how the allotee can step into shoes of the secured creditor when bank itself standing as a secured creditor after charge is registered in favor of the bank? Here the question comes before us in many of the matters. So that's why here, why the word called secured? That's what, though we are all stalwarts in understanding the word secured, but even when we compare, when we try to understand this particular concept between the IBC and Companies Act, still confusion exists, because whether the secured creditor for the purpose of Companies Act is also treated as a secured creditor for the purpose of IBC, or put it other way, whether a person who is not a secured creditor for the purpose of Companies Act can also be treated as a secured creditor under the IBC. Just if he is satisfying, just with the criteria that he is satisfying whatever provided in the class 31 of the Insolvency Backup Code. Here, unfortunately, here the word secured interest, as our friends were deliberating, now it has got a very general word, performance of obligation. Okay, whether performance of obligation will give a secured interest, privilege to a person. Here, that is the only question in hand before us. Today, as of now, there was no clarity exist, though we can take both the views that they are coming within the secured creditor or they are not coming with the secured creditor, but we don't have any provision today or any orders today, any court orders today to justify and substantiate that they can be treated as a secured creditor. If anyone have that any order in your hand, you can tell. I've gone through the orders. I have not come across any such order as on date, which the court says to bring the home buyer as a secured creditor. So still the position is going in the same manner. They are treated only as a financial creditor, not like a secured creditor. Now moving on to that, because we can deliberate enough. We keep deliberating, but still answer we don't have in hand, which is substantiated by a legal provision or legal backing. That's the only thing today we have, challenge to today we have. Okay. So now coming to the claim, I'll take you through so that I will take you through some cases also. So these are the routine provisions. I was explaining to the management of affairs by the IRP. I was telling these are the affairs which, in that one of the things that collating the claim, which I was explaining also earlier. So now collation of claim as a duties of IRP. The IRP shall receive and collate all the claim. Then post collation he has to constitute the committee which we are deliberating. Then he has to maintain an updated list. Then here again importantly there's a circular from IBBA that the duties of all this verification of claim should not be delegated. Okay, so that very important that there's orders also from IBBA on this aspect, wherein the verification of claim should not be delegated, should be done by the IRP and RP. Then going to the claim by operational creditors, these are the way how the operational creditor can file their claim, submit their claim in Form B. Same way financial creditor, they have to file the, of course I will share the PPT to the organization madam, so you can take a copy of it there. So this is the financial creditor, the form and how it should be done by the electronic form, and of course other claim forms and that should be submitted in physical, whereas in the financial creditor alone they have to submit the form only through electronic form, so that they have a acknowledgement for submission. Now existence of debt may also be proved based on the records available with the information utility and a financial contract and record evidencing the amount that has been drawn by the corporate data, financial statement, and these are the thing, even an order of court and tribunal that has adjudicated the non-payment of debt. All this can be the taken as a evidence for proving the debt. Now again, the claims by creditor and clause also the same way. It should be in form CA and it should be in a electronic form where the same way what are the documents, the records available information utility, sale agreement, letter of allotment, payment receipt, and okay. Then workman and employee form D has to be given and the same document has to be, we have to verify whatever is available with the company corporate data and information utility. And the workman and employee of the corporate data in form D, they have to do. Okay. So here important thing is whether there are numerous workmen or employee and authorized may submit one claim form with the proof in form E. That is the one important thing that we need to note. Then by other creditor, it's like form F, a creditor other than those covered under regulation 7, 8, 8A and 9. It's the form F. So existence of debt, here also again, same thing which I was referring that documentary evidence, bank statement and order of the court. Here, importantly, here the IRP and RP may call for such as the evidence or whatever the clarifications as they deem fit from the creditor for substantiating claim. So the creditor, you should bear the cost of proving the debt due to such creditor, that it should not be accounted in the books of the corporate debtor. That's the important thing. There is another order also in this I have come across, I believe. And updation of claim, a creditor shall update his claim as and when, which I already deliberated, discussed it. Then again, the submission of proof of claim, as we were discussing this.
Can I ask?
Then, yeah.
Sir, actually, there are classifications as per this classification list as per the new circular, but it says operational creditor. The EPF should be considered as operational creditor, and there is separate classification for government stakeholder. So now there is a confusion whether the EPF will fall under operational creditor category or it will come under any other stakeholder or government stakeholder. There is a list called any other stakeholder. So will it fall under that category? Government?
See, I think it's a bigger topic to deliberate because there are a lot of what to say, that orders are coming in. Of course, recently also and earlier also there was an order there, Monet Spot, I believe, that the order also discuss about this EPF and yes, I think now section 36. How many of you? I will take you through there and I can, so that you will understand in a better way. Since the query has come on this thing, I will take you through so that our participant friends are there who are actively giving their inputs. So we will take input for this so that it will be useful for every one of us, right? So now coming to your point, what are the whether this EPF and other people? So liquidation estate 36, right? There are many cases coming up in this particular aspect, more particularly on PF, ESI, whether their claim is coming within the liquidation estate, whether it will come within the liquidated estate or not. So based on that, whether they are falling within the ambit of operation. Of course, there are a lot of orders also have come in this, but still, I heard from our professional friends that still notices are issued from PF and ESA and Provident Fund Authority and Gratuity Fund Authority that their dues will not forming part of the liquidation estate, and their dues should be settled first in the section 53 priority. I think the participants, I think you must have come across these scenarios. Can you share your inputs? Then I will share my conclusion part.
Sir, today, even today I had a meeting, SEC meeting, wherein the EPF officer, he is saying employee provident fund is a third party claim. It will not form part of liquidation estate. Even during the distribution, they are outside the waterfall mechanism. they should be given first priority before even starting the distribution as per section 53.
Okay, that's what I took you directly to regular, section 36, because this is the issue recently. I think our RP friends and the liquidator friends are in a situation that they are encountering in the recent time, where the EPF and PF authorities, the pension fund authority, they are claiming that that they will not come within the category of section 53 waterfall mechanism, because this is a third party claim that will not fall within the liquidation estate. So that should not be made part of liquidation estate, and whatever due to them, that has to be first settled before coming to section 53. I think participants must have got experience in this.
So
yeah.
Sorry, in one of my cases, this was a thing, and the payment was made prior to the secured financial creditors. But I have come across one thing besides nature, besides the actual amount of contribution, they also add in their claim penalties and interest. And there is no clarity, though I have considered the whole thing, but should that be also part of the claim? And that also not of a, the limitation period nahi hai. Ye काफी लंबा वो लोग एक what do you say, through system they generate for so many years calculation of penalty and interest, and then they come out with their claim.
Okay, see here, okay, I'll tell you something. As you said, the scenario many of our friends have faced. Of course, in my session also, I deliberated this particular aspects actually. In fact, the participants were giving lot of inputs in that. Then also, the situation still not got settled actually. Actually, here if you see subsection 4, section 36, it says following shall not be included liquidation estate and shall not be used for recovery in the liquidation. Okay. Now, in that asset owned by third party, which are in possession of the corporate debtor. Okay. So, in that all sums due to any workman, employee from provident fund and pension fund and gratuity fund. Correct. Here, the plain reading of it, it gives an understanding whatever the amount standing, to the credit of the provident fund authority, pension fund, gratuity fund, that should not be counted into the liquidation estate by the liquidator, because that amount meant to the workman and employee directly from the provident fund. That's what it means. When I read it, it directly gives in meaning that what are the sum due to any workman employee from the provident fund, so gratuity fund. That is one thing. There's another scenario where you must be knowing that there are companies. A company has got an option to have a private provident fund account without depositing to PF authority, because even many of the companies you can see, they will have a private PF account. Means they will take out the money and put it in separate bank account, and they will maintain it without depositing to the PF authority. It's called private. It is permitted under companies that. That's the option that company has to take, whether to deposit or keep a private account. Even if the company keeps as a private account also in a separate bank account in the name of the company, the liquidator should not touch it, because it has to go to the PF authority. So these two situations alone should be excluded in my reading of this particular provision, 36(4). But I keep getting a lot of points and situation, scenario, issues raised by IP and liquidator friends, that the authorities are making demand to pay interest, to pay penalty, and also they are claiming the PF ESA dues during the CRP liquidation period also. when the company itself is not operating. So all the scenarios keep coming. I think someone if encountered, you can share your experience with this, your input on this. If the scenario if you have encountered.
In case of provident fund, there may be a situation where the employee's contribution and employer contribution are there. Employees' contribution, I think, needs to be taken as in this part. And as far as the employer's contribution, that should become as a operational creditor. That should not come in the PF. This is my view, but just I'm adding a situation. Similarly, in case of gratuity which has not become due at the moment, cannot be taken in this clause. This is again my view. As far as the private provident fund is concerned, it is normally made when there is a separate trust is created and that become an independent entity out of the company, and the company is required to make the periodical payment to that trust as if it is like a provident authorities only, and that fund should have a separate altogether status, and that account cannot be clubbed at all with the company's banking.
Correct. See now
this is my understanding. So as far as the employer portion is concerned, that should be covered under the operational creditor, and as far as the employee portion is concerned, that is to be paid. That should not be included in the liquidation estate at all. That should be paid upfront. And as far as the penalties and all those things are concerned, that should come under the operational creditor.
Okay, but here,
sir, can I add something?
Yeah, please.
Yeah, please.
Sir, PF department asking payment under 7A, 7Q and 14B of the Provident Fund Act. 7A for dues, PF dues, employees and employer, and 7Q is the interest upon the dues, and 14B is the penalty charged by the department. And if we go by the 14B of PF Act, in the particular act, their section, there is a inbuilt waiver condition. It has been mentioned that company under SICA can get waiver from the 14B. But now SICA is subsumed with IBC. So company under IBC should avail 14B. But department after rainbow judgment are arm twisting for getting the 14B also. That is the main problem, sir.
That rainbow judgment they are taking to their favor.
Yes, sir.
The problem here, see,
they are arm twisting, sir. Actually.
Yeah, correct. Yes, in fact, few of my
with due respect, they are arm twisting.
It's okay. See, it's after all our duty that we have to do as IRP liquidator.
Yeah, we have to. We have the punching bags.
Exactly. We'll go by the code. Whatever the code's orders, we'll follow that. So there's nothing that we have to. We'll follow whatever provided in the code, whatever the orders provides for. But now coming to this particular point, here many of my RP and the liquidator friends share this point, particularly our sir, I think our Rajkamal sir was sharing something now. Sir, here the point what you are saying, the private trust should be created and fund will be deployed, means what are the provident this thing accumulated in that, it is as different entity, all that's fine, and everybody agrees with that. Here the only problem comes when there is no such fund exists in the financial statement of the company. Okay, when there is no provident fund or EPF dues or gratuity fund, whatever the pension fund dues appearing in the financial statement, there is no due that is showing to the department. But still department calculates, even till they are sending notice, they are calculating the PF dues and ESI due that ought to have been remitted if company would have been in operation. Suppose the company CRP for 3 years, 4 years.
That I think that needs to be litigated in the NCLT when there is no salary payment, no liability towards the salary, and the PF dues is not there. So in that case, the notional calculation cannot come in the picture. The first thing is that liability based on the actual liability on the salary and workman wages, the liability towards the PF is to be there. Wherever wherever the company has deducted the amount of the employee, the workman, that should go on top priority. That cannot be 53. But as far as the other part is concerned, including the penalty and other things that needs to be covered under the operational creditor only. This is my view.
Yeah, correct. But here the point is they are as one of our madam has shared shared her experience with the department. They are trying to say, and even sending a letters to the RP and liquidator stating that they are not coming within the criteria of 53. It's a third party liability, even though liability is not showing in the financial statement. See, basically the amount should have been deducted and should be reflecting in the financial statement, then only it can be paid. But here in the books, there won't be any amount will be reflecting as due to the PF. Neither amount will be reflecting as due to the PF or ESI, nor a private fund is created and money is deposited and maintained by the company as a trust or whatever the format. So without anything, how a PF and ESI authority is writing to the corporate debtor or liquidator and RP and demanding the dues that they should have paid this much due.
Liquidator can ask them the calculation and the breakup of how the calculation has been derived, and that is substantiated by the.
They are ready to give calculation.
The liquidator can always dispute that.
Here there is no calculation. It's not a big problem for them. They are ready to give. Here the problem is that any company which is coming in CRP, sometime what happens, the company before coming into CRP, it may be inoperative for some years, 1 or 2 years. In few cases, I've seen companies are inoperative 2 years, 3 years and all, then it comes to CRP. But the amount what today the ESI PF authorities are demanding from corporate debtor and writing to RP is that covering those period, even CRP period, and demanding to here the question is that
when the company is not in operation, there is no dues towards the workmen and employees. Correspondingly, there is no dues towards the PF as well. So that will not fall under the 4A3.
So this issue is going on. In fact, I know few letters our liquidator friends also showed to me, and they keep writing that the amount which ought to have been paid if company would have been operational, for that period also they are expecting the company to pay.
That cannot form part in the claim. I don't think that should come.
But of course, now that the orders are keep coming, and 1 or 2 orders also there in that, I think we need to discuss that particular liability portion alone as a separate session. There's so much is there to discuss in that.
Yes.
Yeah, there's a.
Yeah, now we can move to the second point.
Yeah, exactly.
Sort of a time also.
I think we are getting nearing to the 5 o'clock session time is getting over. Yeah, so I will take you through now. See few cases also, so that let's try to conclude with some understanding. Yeah, see, this is the thing which I explained already, estimation. So I will take you through.
It is very dangerous to estimate because it is based on documents only. If you are estimating, then it will be Pandora of challenges.
Yeah. So yeah, the law provides for, and so okay, in the powers of the liquidator, if you see that this is one of the verifying them where we were discussing about the liquidator has got a adjudicating power also. So and to invite and settle claims of creditor, claimant, and distribute the profits, all that is there. And how I was discussing in CRP in regulation 17, regulation 18 and 19 and 20, it talks about claim by OC, FC, and workman and other stakeholder under during liquidation time. And here also the same which I was showing in the CRP, same way the evidence has to be seen, it has to be proved, and same way the claim of the financial data has to be seen and workman employee has to be seen. Same way claim by other stakeholder in Form G, they have to file. Here also we have to see that how for these documents and all verified in support of the evidence that are available. Now the consolidation of claim as to the liquidator shall receive the claims and within 30 days from date of commencement of liquidation process, and the FC should submit the claim to the by providing the record with an information utility. The recent amendment also has come that before filing the matter petition under section 7, the financial creditor has to upload the information to the due liability to the information utility, and with the acknowledgement that they have to file the application under section 7. That's a recent development has come. The OC may submit the claim to the liquidator with the supporting document, and this is the same the process what we keep following under the CRP. Same thing that we have to see. If a claim or part of the claim is found to be false, the liquidator shall endeavor to recover the cost, for the whatever the cost incurred for the verification that can be recovered from the thing. Same way, determination of quantum of claim also, where the amount is claimed is not precise, the best estimation could be made. And the verification, the liquidator shall receive a claim within 30 days of the liquidation commencement and verify the claims within 30 days from last date of receipt of the claim. Either he may have to admit or reject, and otherwise, then he should communicate within 7 days, where the creditor has got a provision to go on appeal against the decision of the liquidator. The verification there is, and the admission and rejection of claim as I was referring that should record in writing the reason for such a rejection. He should communicate his decision within 7 days from date of verification. Then list of stakeholder also has to be prepared, and this also to be filed within 45 days with the NCLT, and additional information also should be updated. And availability of list of stakeholder also should be made inspection by person who is submitting the proof of claim. Same way, inspection by members should be displayed in the website, should be filed in the electronic platform. Stakeholders consultation committee also should be constituted as per regulation 31A. And these are the provisions that has been introduced little later after the code has come, with effect from 25th July 2019. Claim from statutory and government authority, which we were discussing. There are few matters which the NCLAT and even Supreme Court in few matters have observed that a claim of statutory authority, government authority, comes under the category of the operation creditor. So this is the compilation of the forms for under during CRP and during the liquidation. I think so these are the other things. I'll take you through few case laws. So in this particular case, if you see SSMP Industries and Percon Food Processor, so you see it was held that since the proceeding before AA or summary, the adjudication of disputed claim for discrimination of value was continue in arbitration. In that particular thing, it has given a permission to go on arbitration. Then if you see the Standard Chartered Bank, this is Satish Kumar Gupta, this is another important judgment here. Here the NCLT, that AA has noticed that RP has no jurisdiction to decide and reject a claim. It is only where what we are discussing, it is the observation made by adjudicating authority, where the association on behalf of corporate have moved before the Supreme Court even during the pendency of Florida having lost. It was duty of the RP to bring facts before the notice of the adjudicating authority. In fact, if you see Regulation 13, the RP shall verify each claim as on the date of insolvency commencement. Thereafter, he has to maintain a list of creditors. So it becomes the inbound duty of them, the RP, to maintain the list of creditors. Even in Swiss ribbon matters, if you see, as I was referring that, it is made it very clear that the role of RP, that means the RP's role is only an administrative. Okay, it is not, that's why we keep discussing that the RP can collate and collect and collate and verify the claim. The adjudicating power is not given to the RP, and which is confirmed, reassured by many of the orders that only the liquidator has got adjudicating power, which RP and IRP does not have. They have only administrative power. Okay, and again, if you see in Central Bank of India, this is Ravindra. So whether any penal interest in the claim can form part of the claim admitted, but interest, but after that the interest should not be. That means the time when they are filing the claim, that time what are the penal interest they put it, that can be considered, but not thereafter. After that, they should not calculate the interest for the delay, till the making the payment. That should not be considered. That's what held by Honorable Supreme Court in Central Bank. Same way, another matter, if you see that Dutch forfeit AG and the others, Mrs. Uttam Galwa Steel, if you see, it was clarified by Honorable NCLT that the whole idea is that because of operation data claims, interest for delayed payment does not mean the claim becomes a claim of financial debt. Here the idea is that just because of the OC is claiming interest, because interest comes for the time value of money. That's what even many orders have also passed. That's why the person who is lent money is considered as a financial debtor because of the time value of the money where the interest is charged by them. So it has been very clearly made it in this particular order whereby operation creditor, just because of they are charging interest, they should not be deemed as, they should not be given a cap of financial creditor. They are only a operation creditor, even they charge interest for the due amount. In the matter of consolidated construction, again the matter is, if we see in this particular matter, Supreme Court, while considering the position of court, relied upon judgment which I was referring, the Pioneer Urban Land and Infrastructure, that the appellant is a purchaser. It can be an operation data for providing an advance to the corporator. But if you see the Supreme Court, Honorable Supreme Court has observed that as per the definition of operation debt, the claim must have relation with the provisions of goods and services. The definition does not specify who is to be the supplier or purchaser. Therefore, if you see section 8(1) of the code, this rule 5(1), an OC can issue a demand notice or invoice. That's the reason they are taken. That means that the Honorable Court has held that as per MOA, the corporate debtor took over the property and will be liable to pay tax. Here, what is the background of it is that it is a contract between the consolidated construction with the Chennai Metro CMRL Limited, wherein the CCC has given awarded a contract. Okay, means CCC got a contract awarded by CMRL, wherein the material that is required for the project, the CCC has engaged Hetero Energy to supply the product in this particular matter. Okay, the Hetero Energy, before supplying, they were insisting for advance. So since they are insisting for advance, Hetero Energy, for supply of material, the consolidated construction had requested the CMRL to release the advance amount. Here, CMRL directly, instead of releasing the amount to the consolidated construction, they directly release the amount to Hetero Energy as advance for the material that has to be supplied for the project undertaken by the consolidated construction. Now, subsequently, what happened? The CMRL cancelled the project with the consolidated construction. So, what happened? They were demanding back the Hetero Energy, the advance whatever given by CMRL, but they were refusing to repay the amount what is received from the CMRL. What happened? CMRL deducted the money due that is payable to the consolidated construction, what are the amount paid directly by CMR to the Electro Energy. This is the case. Now, subsequently, this Electro Energy was originally a proprietorship concern which was acquired by the company. That's what here Electro Energy Solution Private Limited. So they were keep arguing that that sole proprietorship only was a party. So Electro Energy Private Limited was not a party. But whereas the MOA was very clear that that private company is to take over the proprietary concern. And here the question, here only the Honorable Court has observed, saying that since the MOA provision is there to occur the property concern, so Electro Energy is liable to the consolidated construction to make the payment. The reason being, it's not the question of seller, purchaser and all. So purchasers is also very much covered within the ambit of the within the ambit of the operation creditor. Therefore, the Honorable Court said that Electro Energy has to make the payment to the consolidated construction. That's what the case here, wherein they brought in the purchasers also within the ambit of the operation creditor. So if you see in this particular case, Adel was, as if this is Adel, landmark matter. It is a principal bench case. Again, if you see this rejection of claim on the ground is not because of provision, it to be directly. So here they pass a comment that we wish to make it clear that all the resolutions shall make note that the repeated order of NCT clarifying the claim of applicant like present one could not be rejected on the ground of delay. But subsequently, now recently, Honorable Enclave had said that resolution professional should not encourage, the claim which is received delayed. Okay. So I think as our friends were deliberating, that there are a number of orders with the slight changes, one different from other. So now if you see additionally another one more matter also Honorable Principal Bench in 20th May 2019, the matter of 21st century, they also said that no, the RP should not simply leave it. It is only a held to be directive, so they have to consider. But subsequently, Honorable Enclave has passes different order against this. In the matter of Tata Chemical Raj, and this is Raj process equipment, if you see that, so here again, it has been argued that claim of operating data is not related to the goods, including employment or debt. It is only related to non-payment of advance money. So, and they were claiming further compensation on account of alleged loss incurred by housing. So, it is again ordered that no, it is also covered under the operational debt. So I think any questions, I am ready to take it. So I think enough we deliberated. So I think that's the reason I would have otherwise taken.
Good evening, sir.
Yes, ma'am. Tell me.
Sir, can claim of gratuity be included in the list of stakeholders during liquidation?
Sorry, can you come again?
Can claim of gratuity be included in the list of stakeholders, and can the gratuity holders hold place in stakeholders consultation committee?
Yeah, the provision 31A provides the representative by all the stakeholders, right? The stakeholder, as per the recent amended one, you are telling, no?
Yes, sir.
The amended one, the recent one, 31A.
Sir, as per amendment, recent amendment, that IRP is supposed to send all creditors to invite the claim apart from the public advertisement.
Yes.
And if IRP doesn't receive the address, email ID from the corporate debtor due to non-cooperation, then in such case, whether IRP will be held liable?
See, the idea is that they are in one of the matter, in home buyer matter, they said that even not only home buyer, even in a government authority, one of the matters that has been observed, even whether the government authorities, whether they give claim or not, it is the responsibility of RP liquidator to go into the books of accounts and see that they are making them part of it. Okay.
So you mean to say we should include all claims which are showing in the balance sheet in the IBBI website, whether they file it or not, then what is the purpose of filing of form B, C, D? It should go as per the balance sheet only.
So one of the matter, the order, I think the name I couldn't recall now, that one of the order observed by the court, wherein they said you should not, the RP liquidator should not only restrict only to the advertisement, they have to also go through into the financial statement and find in case of factory liability.
What will be the best practice for IRP if IRP gives public advertisement and IRP doesn't receive the claims which are showing in the balance sheet?
I think if you see, I think 31, madam, you are asking about the point about
gratuity, sir.
Yeah, see, if you see the consultation committee form, you are telling making them as a member of stakeholder consulting committee?
First, sir, will the gratuity holders be included in the list of stakeholders, and whether they'll held a position in the stakeholders consultation committee, both?
In stakeholder, if you see that the secured financial creditor and their representative, same way, and unsecured financial creditor, then workman employee.
Excuse me, sir.
Yeah, please. Yeah, tell me.
Hello.
Yeah, tell me.
Hello.
Yes, sir, tell me.
Payable if it is termination of service after 5 years, or it is some debt. Okay, so there in this case, if there is no, if there nobody is he is not leaving the job and doing the job, there is no liability of gratuity.
Okay, so no, sorry, I couldn't get your point. I couldn't get your point. Sorry. Sorry, can you come again?
I am saying, sir. I am saying if you are not completed the 5 years of service, and there is no debt, so there is no liability of gratuity, na? If he is working in the company.
Yeah. See, when there is no liability, we are telling the gratuity holder, or you are telling an employee, you are telling, as an employee, you are telling.
As an employer.
No, your question I'm not really getting fully.
Sir, there is one case law. NCLAT has ordered, like in Mr. Anil Goyal's some case, they mentioned that the claim of gratuity is payable only at a future date, that is happening of an event like retirement, resignation, etc. So it cannot be said that this is subsisting claim. So it should not be included in list of stakeholders, and consequently it should not hold a position in stakeholders consultation committee.
I think
so there are
NCLAT order, right?
Yes, sir, NCLAT order. So there are different views. Some professionals are adding gratuity claims in their list of stakeholders, and some are not. So, what is your viewpoint on?
Have they given have they given a form to you, this authorities?
Sir, actually, I'm on behalf of ICSI IIP. So we have seen some instances where some IPs are including this and some IPs are not including.
Actually, what happened? What happened, Nikita? In practicalities, employees are filing their claim along with the gratuity amount.
Yes, sir.
Including the gratuity amount.
Okay.
So it is better to avoid any dispute, in my view, which I had done in my cases. I have paid the gratuity along with the employee's dues.
Okay. Yeah,
with the permission of the stakeholder committee.
Mr. Pankaj, was that gratuity crystallized, that they have served the 5 years period?
Yeah, obviously, then only it is applicable.
Otherwise it won't be.
Otherwise, it will not be applicable.
Yes.
Otherwise it won't be.
Even if there is no gratuity fund, sir, like was there proper gratuity fund available?
Yes. See, some companies take the LIC policy for gratuity. So we paid from the our liquidation account, and we reimburse the whatever amount lying in the LIC policy we take in our account.
Okay.
So in one of my case, I did it like this.
Sir, what I have raised the question, it is really, it's a, It is as per the.
One at a time, please.
Sir,
Participants are requested to please raise their hand by one.
Yeah, one by one.
Sir, I have raised one question regarding this current scenario after the amendment of this 16th September 2022. That IRP has to send email or communication to all stakeholder creditors.
Yes, that is.
So my question is that if IRP has given public advertisement, he doesn't receive claim from all creditors, and IRP does not have all the address or email ID of the creditors. So what best course of action should be adopted by the IRP?
What are the available? See, based on the records available with the corporate data, whatever the email ID that you could able to retrieve from a corporate data.
Usually, this CD management doesn't provide all these details.
Then we have to go move an application only before the court to get the details.
That is
that
application 19.2 goes for 3 months, 6 months, 9 months.
Yes, it's a practical problem. Better to search, go for the NCA search and take the registration detail, and from there directly mail to the chairman office of any bank.
That is true, but for secured financing creditor, you are right that I have done. But I am asking the operational creditor. There are hundreds of operational.
Sorry, other people difficult only without the detail you can't do. See, you have to see that you are trying to take out maximum detail in the corporate data. If the corporate data are not cooperating, you have to move an application for non-cooperation. What to do?
Then sir, how to safeguard IP's interest in this so as to cooperate whenever there is a NC issued against that IP that you have not followed. So in order to prove your your efforts you have taken, will that suffice? Will that hold?
It is important that that to show that the effort is taken by RP and liquidator. Okay, that's a very important today actually.
Okay.
Sir, I have some addition in the gratuity case.
Yeah, tell me.
Actually, sir said we paid the gratuity. Gratuity is payable only 2 cases. One is the premature death, or after 5 years he gave the resignations. You can't pay. But the company is doing the company making the provision, the gratuity payable, because they have to be paid after 5 years to the employee. So they are making provision in the books of account. It is okay. But you can't pay before the after resignation of 5 years and before the premature death of the employee. But everybody have to make the provision in the balance sheet. If there is a liability after 5 years, they are making the provision in every year in the books of account. Is a legal investment and gratuity.
See, actually, this particular issue is there in a different scenario. This issue, gratuity issue, is coming, and like a PF department issue like that, this gratuity issue also is coming. We have to go case by case. We have to see the legal situation, and accordingly only we have to deal with that, because it won't have a straight cut answer for every scenario. Scenario differs, then answer differs.
It's a good platform that we can see to the known persons here. So it will be better if everybody opens their window.
I think the opportunity to see everyone. That's why I wanted everyone to deliberate, so that we get the knowledge. We get our inputs. Yeah.
Yes. Raj Kamal ji, Sanjay Jha ji, Pankaj ji, all known faces are there.
Good. In fact, we need a separate session only for statutory authorities. How to deal with the claims and issues of statutory authorities. Because that much is there to deliberate.
In one of my case, PF department is filing its claims after 4 years. Even the company went into dissolution 2 years before. Dissolution order has passed. Everything has been closed. Then PF department is assessing their penalty, prosecution and all after 4 years.
Sir, congratulations.
Now PF department is very active. They are filing their claim within 7 days or 8 days after the public advertisement.
Jain sahab, I received a claim after 4 years.
So that is before Vidharva. After Vidharva, they are very active.
Yes.
No, now only they understood what is what. See, now only they are reacting. Problem is the old cases and also now they have started reacting. That's the pathetic position actually.
That's the pathetic position.
That's a pathetic position.
What should be form for this PF department for in case of CRP, whether it should be B or F?
Other claims?
They have to come another
F. Okay.
It has to be F.
Sir, I have a small query. So far as like regarding like all these statutory bodies, they become a part of your stakeholders. So whatever liquidation costs are there, are they going to share that, or is it a legitimate demand from the liquidator to demand?
For what? For what, sir?
For estimated liquidation cost.
Correct. Okay. Whatever the cost incurred by liquidator, that has to be adjusted, right? In the realization. What is the issue here?
The issue is that suppose the liquidation cost is there, and there are separate class of stakeholders, including financial creditors and operational creditors and government authorities. So who all are going to distribute and share the responsibility of liquidation cost?
No, that and all you ought to see. There is no responsibility. Of course, now recently only it got amended. No, that it become responsibility of the stakeholders to see when there is no. The company that is not having a fund position, the liquid position.
Yes, the company is not having sufficient fund to, meet the liquidation cost.
There is a provision some time back introduced in the liquidation, wherein it become responsibility of 2A, I believe, liquidation cost 2A, I believe. Okay, just you can go and see 2A. The latest there's an introduction of provision wherein it said when the company is not having a liquidity, that the members of the stakeholder should contribute.
Only financial stakeholder or operational as well?
I think so. I think 2A we can see directly here, right?
But in case of financial creditors who are secured, they don't form part of SCC, no? Who have who have not relinquished as security.
Relinquishment or non-relinquishment is a separate issue. So far as sharing the responsibility, the cost, it goes to everybody.
Okay, in case of non-relinquishment, still they have to contribute some
Yes, Vaisali ji.
See, wait, I'll tell you. Wait. See, there is a provision 2A which I told you, right? In that it very clearly says, you want me to share the screen? You want to share the screen? Wait. Yeah, can you see now? So 2A, contribution to liquidation cost. I told you, this is, I think, yeah. This has been inserted 25th July 2019. I think this circular, no one can skip, because it is given exemption, then again that exemption is removed now, right? That it has come, where the committee of creditor did not approve the plan, and the liquidator shall call upon financial creditor being a creditor to contribute to excess of liquidation costs over the liquidation assets of the corporate debtor as estimated by him, in proportion to the debt owed. Okay, financial debt only it says.
Yeah, this talks about only financial creditors need to contribute.
Talks about financial debts. Okay, yeah. Yes, it talks about.
Yes, sir, only financial creditors have to contribute.
Yes. It talks about that. That's why I told you, I have seen somewhere. 2A, it's there very much, but the exact language only I couldn't recollect actually. Okay. This is a position actually. So, any other thing? I think we are approaching 5:30 or 5:20. Okay.
Yeah. Although it's a cold wave is going on in Delhi, but I don't think there is any harm in opening the virtual window.
Okay. Okay.
खिड़की खुला रख सकते हैं.
Good. Madam.
कोई रजाई में भी तो बैठे हुए होंगे.
वर्चुअल विंडो में ठंड नहीं लगेगी.
I think, Madam Radhika, if you are there, Madam, you can conclude. We can conclude, ma'am.
Yes, sir.
Because liquidation is a stress matter, so we should get this stress also. De-stress.
Yes.
Okay, we'll all again meet up in another session. Probably madam can organize for.
Okay, thank you, sir. Very good session.
For statutory authority, there should be a separate session, madam. Lot of issues there.
Thank you, Dhanapal, sir.
Yeah.
Thank you, sir.
Thank you.
Thank
Yes.
you,
Thank
everybody.
you.
Thanks to all.
Thank you very much, sir. Thank you for taking out and giving your valuable insights. And thank you all.
Fine, madam. Thank you for the opportunity and thank you all for your patient listening. Thank you.
Sure, sir.
Have to speak.